Hello and welcome to SEO Daily. Today we'll be breaking down day 15 of arguments in the abrogation of Article 370. On day 15, respondents concluded their arguments after 5 days of countering petitioner submissions. The day's hearing began with charged statements by Solicitor General Tushar Mehta, who informed the bench that the lead petitioner, Mr. Mohammad Akbar Lone, had publicly chanted Pakistan Zindabad in the Jammu and Kashmir Assembly in 2018. Solicitor General Tushar Mehta argued that a lead petitioner saying Pakistan Zindabad on the floor of the House has its own seriousness. He stated that the court must look into who is contesting the claim of continuing 370. He demanded that Lone must submit an affidavit declaring his allegiance to the Constitution of India and that he strongly opposes terrorism and secessionism by Pakistan in Jammu and Kashmir. Hearings resumed after this scuffle in court. Senior Advocate V. Giri argued that Article 370 established a kind of relationship with India where the President needed the consent of the Jammu and Kashmir government to make laws for the state. This meant that Jammu and Kashmir was on a different plane than other states. The abrogation, Giri suggested, removed this difference and upheld Dr. Ambedkar's vision for India. Additional Solicitor General Natraj argued next, focusing on the federal structure in India. Article 368, which deals with amendment of the Constitution, states that certain amendments shall also require to be ratified by the legislatures of not less than one half of the states. These words, Natraj said, incorporated the doctrine of collective consent and upheld federalism. In contrast, he argued, Article 373 only required the recommendation of Jammu and Kashmir's Constituent Assembly. Therefore, Article 370 did not contain the features of federalism, he said. Abrogation of Article 370, therefore, would not be a violation of the federal structure in India. Senior Advocate Mahesh Jethmalani argued next, appearing for some members of the Gujar Bakarwal community. He claimed that they constituted over 73% of the scheduled tribe population in Jammu and Kashmir and were completely in support of the abrogation, as it gave them protection and reservations for the first time. He then addressed the petitioner's contention that the union wrongfully used Presidential Order CO 272 to change the meaning of Constituent Assembly to Legislative Assembly under Article 367. Jethmalani argued that this was permissible because historically these two provisions were used synonymously. The bench, however, pointed out that Jammu and Kashmir did not have a Legislative Assembly in the past, which is why the Constituent Assembly often assumed that role. However, this changed after the J&K Constitution was adopted and the state got a Legislative Assembly. Jethmalani responded that if there was a constitutional authority that could take the place of the J&K's Constituent Assembly, it had to be the Legislative Assembly. Senior Advocate Guru Krishna Kumar appeared on behalf of a set of people who represent displaced persons residing in Pakistan-occupied Kashmir. He argued that Section 6 of the J&K's Constitution and Article 35A of the Constitution created anomalies that gave special rights only to the permanent residents of J&K and not the displaced persons residing in POK. The presidential orders which abrogated Article 370, he said, rectified these anomalies. He submitted that approximately 23 to 24,000 people had received their domicile certificates since the abrogation. Sibal interjected at this stage, pointing out that Article 35 was not being challenged in this batch of petitions. Krishna Kumar, however, said that he was referring to this article as an anomaly and contended that restoring Article 370 would also restore these anomalies. In what can only be described as a chaotic turn of events, 15 counsels appeared before lunch break to argue for various interveners in the case. Most notably, Advocate Kanu Agarwal argued that Jammu and Kashmir's Constituent Assembly did not have any original constituent powers, as the erstwhile ruler of Jammu and Kashmir had recognized the supremacy of the Indian Constitution. He had acceded all sovereignty to India when he signed the Instrument of Accession, and therefore, J&K's Constituent Assembly and the Constitution it created were based on derivative powers, which was subordinate to the Indian Constitution. Advocate Archana Pathak Dave highlighted that the women of Jammu and Kashmir had regained the rights to acquire property and other benefits even if they married someone outside the state, and this happened after the abrogation of Article 370. Other interveners reiterated that Article 370 was a temporary provision and its abrogation benefited the people of Jammu and Kashmir vastly. With this, the respondents' argument completed in the case. Now it was time for rejoinders from the petitioners. A rejoinder is where a petitioner has the opportunity to reply and counter to the respondents' arguments. Senior Advocate Kapil Sibal opened the rejoinder, by tackling the union's argument that the status awarded to Jammu and Kashmir was not special in any way. Sibal contended that the historical context in which the instrument of accession was signed was distinct to the region and therefore it was in fact special. Sibal then addressed the respondents' argument that the President had absolute discretion to pull the plug on Article 370 after the state's Constituent Assembly was dissolved in 1957. The proviso to 373, he said, had two key requirements. One, that the recommendation of the Constituent Assembly is necessary, and two, that it was received before the President made the decision to abrogate. He argued that this process cannot be reversed. Chief Justice D.Y. Chandrachud pointed out that there were significant silences in the provision. What would happen when the slow integration envisaged for the state was complete? The silences, he said, led to the conclusion that framers of both the Indian and the Jammu and Kashmir constitution left it to the wise acts of statesmanship. Sibal responded that the court could either interpret 370 with text and context, or we find something which is not there. Reading of the text and context, he said, showed that the recommendation of the Constituent Assembly shall be necessary as per Article 370, Clause 3. Sibal then argued that the standard process, as recognized by Section 53 of the J&K Constitution, was that the governor required the aid and advice of the Council of Ministers to dissolve the Assembly. Only Sections 36, 38 and 92 were exceptions to this rule. In every other situation, the government needed the aid and advice of the Council of Ministers. Sibal pointed to Constitution Bench judgments that show the governor could not, under the circumstances, dissolve the Assembly. With this, the court completed its second last day of Article 370 hearings. Make sure to watch all the episodes of SEO Daily so far, where we break down 16 days of complicated arguments based on constitutional and political histories of Jammu and Kashmir for you. Thank you for watching.